So what happens when two painkillers sound almost identical? You've got one well-known brand, and then a new competitor pops up with a strikingly similar name. Well, it sparked a legal battle that had a really surprising twist, revealing the true cost of copying a name. Let's dive in.
All right, so here are our two main players. On one side, you have IPCA Laboratories and their established painkiller, ZERODOL, and on the other, Anrose Pharma with their new product, ZEROVOL P. I mean, just say those out loud. They're incredibly close, right? And that's exactly where our story gets started.
And this really is the million-dollar question, isn't it? Was ZEROVOL P just a crazy coincidence, or was it intentionally designed to kind of ride on ZERODOL's reputation and maybe confuse a few customers along the way?
Well, things got serious pretty fast. IPCA Labs took Anrose Pharma to court, and their argument wasn't just, hey, you're hurting our business. No, they claimed this new, similar-sounding name was actually a potential risk to public safety.
Now, to really get where IPCA was coming from, you have to look at the history. ZERODOL wasn't some new brand that just appeared. IPCA had owned the trademark since way back in 1992 and had been selling the product since 2003. They had built up a solid reputation for over a decade before ZEROVOL P just suddenly appeared on pharmacy shelves.
So legally speaking, the whole case hinged on two key ideas: trademark infringement and something called passing off. And put simply, that just means IPCA was accusing Anrose Pharma of trying to trick people into buying their product by making it sound almost identical to a brand they already knew and trusted.
Okay, so this is where things get really fascinating. How does a court actually decide if two names are too similar? As it turns out, it's not just about how they look spelled out on a box.
The court relied on this super important principle from a previous Supreme Court ruling. The idea is simple but powerful. You can't just look at the words, you have to listen to them. How a name sounds is just as important, if not more important, than how it's spelled.
So here's kind of how the court breaks it down. They don't just sit there comparing two boxes side by side. They try to imagine a regular person, maybe someone in a hurry at the pharmacy who has an imperfect recollection. Would that person get confused? That's the real test.
And to really hammer this point home, the court looked at a past case. Check this out. The names Sriambal and Sriandal. They definitely look different when you write them down, but the Supreme Court had already ruled that they were phonetically similar enough to cause confusion. This was a huge win for IPCA's argument because it proved the sound of ZERODOL and ZEROVOL was the real issue here. Now, just when you think this is a straightforward legal argument about sound and spelling, the case takes a really bizarre turn. The defendant, Anrose Pharma, they just vanished.
I mean, this timeline really shows how strange things got. Anrose Pharma was officially notified about the lawsuit way back in 2014. And then, crickets. Total silence. They never filed a defense. They never showed up. For any company in a major lawsuit, this is an incredibly risky and very unusual move to make.
The consequence of this no-show was huge. I mean, think about it. Since Anrose Pharma never challenged any single claim, the court had to accept everything IPCA said as 100% fact. It's like winning a debate just because your opponent didn't even bother to show up.
So, with the defendant gone and all the evidence pointing in one direction, you'd think the verdict would be a simple, open and shut win for IPCA Labs, right? Well, the court had a few surprises up its sleeve.
So, IPCA had asked the court for 5 lakh rupees in damages to make up for the harm done to their brand. And since they were unopposed, it seems like a sure thing. But did they actually get it?
The answer was a flat no. And this was the first major surprise in the judgment. The court denied their claim for damages completely.
And the reason was actually pretty simple. The judge noted that, yeah, IPCA proved the infringement, but they never brought any evidence to the table showing they had actually lost money. It's a key lesson, really. In court, you can't just ask for a number. You have to prove it.
So no damages. You might be thinking Anrose Pharma got off easy by not showing up, but that brings us to the verdict's second and much, much bigger surprise. The real cost here wasn't in damages at all.
The court ordered Anrose Pharma to pay 15 lakh rupees. That's 3 times what IPCA had even asked for in damages. But this money wasn't called damages. It was awarded as exemplary costs. So what does that even mean?
Well, the judge's reasoning here was layered. First, the court decided that the choice of name was intentionally dishonest. Second, just disappearing from the lawsuit, that was seen as a pretty clear admission of guilt. Third, and this is so critical,
because these were medicines, any confusion could pose a serious health risk to the public. All of this led the court to send a really strong message. This kind of behavior will not be tolerated.
So what are the big takeaways from all this? Well, first, how a brand name sounds is absolutely critical. Second, ignoring a lawsuit is one of the worst financial decisions you can make. Third, when public health is on the line, the courts are going to be much tougher. And finally, judges have this power to use exemplary costs, not just to cover legal fees, but to actively punish dishonest conduct.
Ultimately, this case goes way beyond just legal strategy. It leaves us with a really crucial question for any business out there. In a crowded market, how much is your brand's name truly worth? And what's the real cost of protecting it?